the question that I was asked to look at was, how do you actually get to this question of the truth? And of course, this was an issue that preoccupied the Human Rights Violations Committee. How would we get to the truth? And clearly what that meant is that we would have a number of tasks. Firstly, one of the things that was written into the mandate was that we should provide victims with an opportunity to have a safe place in which they could come forward and share with the Commission what had happened to them. Now that was a very important process for both the healing and closure issue. But it did not necessarily lead to your being able to say, this is the version of what happened. Because what you have in South Africa are many contested versions of what the truth was. And what that meant then was that, yes, the Commission would be documenting people's testimonies, and that would be important for the historical issue, for the cathartic process. But the Commission really had to engage on this question of how was it going to uncover the truth. And that meant that it had quite early on to do a kind of outline or mapping of how the conflict had played itself out in South Africa. It had set up an investigation commission within the Commission, which was chaired by a commissioner, and in each of the provinces it had a mini investigation unit. The problem, of course, is that we also had policemen who had been serving under the former state, who were seconded to us, and they were also working with many of the human rights activists. And often you had a conflict between them, and you also were quite clear that there were many who were really sweepers meant to ensure that you don't get to the truth. And so we had to do our own documentation, we had to do investigations very early on. We set up a comprehensive database, and in fact the person who set it up went on later on to provide much of the war crimes inquiries with that kind of database framework, which then allowed us to do our work. And of course, what we had to do was use what we call the carrot and stick approach. We have the power to subpoena people. Now, of course, the first time you invite them to come. When they choose not to appear before you, then you subpoena them, and you use that period to extract information from them. We also, of course, had to use the amnesty process. And in a very famous case of a young man, Stanza Bopape, who had disappeared during the 1980s, he was a member of the youth organization, and he had been picked up by the police, who denied for a 2-week period that they had held him. Later on, they confirmed they had Stanza. But they then alleged that Stanza had escaped from custody. Now, how someone who has been tortured, who has leg irons and, what do you call this thing, handcuffs on his hand, can escape, I don't know. But the police alleged that he had escaped. And many years later, they actually put on, at the time that they alleged his escape had happened, they put on his khakis, and they ran through the mud, and then they took footprints, and they put that in the police docket and said, this is proof of the fact that he escaped. And often when there was a bombing, there was the Ellis Park bombing, then they would set out the rumors, Stanza had been sighted. We, of course, were approached quite early on in our work by a constable called Johnny Mokuleng, and he said you could take us to where Stanza, in fact, had been buried. We called upon our colleagues from Argentina, the forensic team, and they helped us to dig, and we didn't find anything. But what we then did is we called for the docket, and we issued subpoenas to 5 policemen. On the morning that these policemen were going to appear, 10 people, including the Minister of Law and Order, 2 generals, applied for amnesty. And they applied for amnesty for the abduction and the accidental death of Stanza Bopape. What they alleged, in fact, is, yes, they had picked Stanza up, yes, they had tortured him, but in the torture room, they alleged that he had a weak heart. And so when they attached the electric wires, from the telephone thing which they cranked up, because of his heart condition, he died. And they blamed the heart condition and not the torture for the fact that he had died. Now, this emerged in the Human Rights Violation Section 29 hearing. And what that helped us to do was to piece that together with what the mother had said and with our own investigation. They later alleged that they had thrown his body into the Komatipoort River. And what one of my investigators did, he took a dummy that would have been the dead weight size of stanza, and we drove up to the Komatipoort River. We said, now tell us how you did it. He couldn't even pick the dummy up from the book, and it was very clear that he was lying. He was a general from the East Rand, the eastern part of the police services. And that made us realize there was something really fishy about the story. The Amnesty Committee, of course, was made up of judges who, in my view, took a very narrow, legalistic perspective on how they dealt with amnesty. They didn't really look at international human rights law on the enforced disappearances or abductions issue, and they gave them amnesty for the abduction. The question of the missing body remains an issue, and of course, when we went to see Stanza's mother, she said, till you bring me back the body, I can't ever put closure to this. Today, of course, if you drive through Pretoria, I think one of the names of the streets has been changed into Stanza Bopate Street. And while that, form of memorialization may bring some closure for the mother, the fact of the matter is that this remains an outstanding issue. And what I'm trying to illustrate is this is how the Truth Commission worked. We would issue subpoenas to people that we had information on. And if they thought, if they weren't sure about what information we had, then they would apply for amnesty. They didn't come to the amnesty process because they were genuinely committed to getting this off their chest. What they wanted was an expedient way of ensuring that they would not be prosecuted. Secondly, that they would not have civil claims filed against them. And they only came if they thought you had information. And that placed an enormous stress on the Commission. Because if you look at the way in which the ICTY or the ICTR works, they have hundreds of investigators. They're only able to bring one case in maybe like a 5-year period. So it tells you about how we had to work smart, but also under enormous constraints. One of our very enthusiastic investigators one day rocked up at one of the military bases, and he demanded access to their archives. And the military went to the highest level. They went to President Mandela, who referred it to Thabo Mbeki and President de Klerk, and there was a bit of a démarche with the Truth Commission on why we had rocked up in this way without giving the military defense notice of the fact that we were going to seize records. And what happened, I think, became, in my view, one of the most monumental mistakes made by the Commission. We agreed that in future, we would forward requests for information through a nodal point, which the military set up. I would call it a fudging point, because things just got stuck there. And so what we learned about what the military was doing was through what I call the joint military police operations, and of course through the renegade military officials who came to the Commission and to the archives and material that we were being given by our investigators. I was very fortunate. One of the things that happened with the Commission is we had investigators who were seconded to us from many European countries, and one of my best investigators was a Swedish colonel who really went down on getting to the bottom of things. And that really, really helped with how we got to this question of the truth. Now, of course, a very important area for us was the hearings, because the public hearings gave the victims an opportunity to speak to the Commission and to tell their story. But often you would see, the victim crying. I think sometimes the Archbishop would cry, and it's become a really very sensitive moment. But it became even more difficult when you sat in the amnesty hearings, because here you had these very hardened perpetrators who were coming there kicking and screaming. They didn't really want to be there. And also it was a really terrible process, because your wife, your family, your church didn't really know that this is the kind of things you had got up to. And now suddenly you were confessing them in public. It was often a contested space, because they would give you some truth and not enough truth, and you would have to try and find how you got to that. And so very soon we agreed that there would be, what we call the low-level corroboration process, which we would use on most of our ordinary victims' cases to make findings that people had in fact suffered a violation, and that we would use 2 independent sources to corroborate that, but that for our big findings or window cases, we would have to do proper investigations. And that meant we had to pay our research teams, and key investigators would look at these window areas, because after all, we were expected to tell the country what had happened during the past. Now, the commission was really constrained by the amount of times it was in court. And it started with one of the victims, I think, mothers. She had read in a newspaper that Dirk Coetzee, who had started up Vlakplaas, had said that yes, he knew who the killers of her son were. And she wrote to the commission and said, I want to make this statement, and I want to appear before the commission, and I want the commission to find out what has happened to my son. A number of the policemen who were involved in it, and they were from the Eastern Cape, including Gideon Nibo, they then went to court to stop her testifying. And in the first court, the court upheld their case and said, well, they need to be given a right of reply. That case then went to a full bench in the High Court in Cape Town, and that court said, no, this is nonsense. You've never had any court in the country say that a perpetrator needs to be given a prior right of notice, because commissions just don't work that way. Of course, we were at that point talking to all of the judges about them appearing before the commission in a legal hearing. And the Chief Justice, when this case went to the appeal court in Bloemfontein, didn't like the idea that he should be under scrutiny, or his judges. What we got was a different judgment, which read 3 separate sections in the law conjunctively. And what that did is it imposed a major burden for the commission. It said that if a victim was going to appear before the commission and intended to mention a perpetrator, then we would have to notify the perpetrator that you are going to be mentioned. We would then have to give them the right to make either a written submission or an oral submission. And if necessary, they had the right of cross-examination in a victim's hearing. And, that created an enormous tension. But nevertheless, at the end of it, the mother in this case finally appeared at a hearing of the Truth Commission, and she made the points, and these guys then had to apply for amnesty. But it gives you a sense of how legally we were constantly in court, because this was such a contested area. And that meant that if we named somebody or said anything, we had to be absolutely clear that it could stand the test of time, because every single political party was going to take us to court. And at the end of our work, when we were compiling the list of findings, I think Richard Lister and myself, at one point we were dealing with senior counsels for, I think, a 3-month period about, if you don't take that out of your report, because we also, before we could make the finding in the report and publish it, we had to send them a prior notice and say, this is the finding we intend to make against you. If you want to respond, then you have an opportunity to do so within 14 days. That, of course, didn't stop the politicians. And President de Klerk took us to court in the final week of the commissions. It was going to give over its first report to the government. He took us to court to stop the publication. We were advised by our lawyers at the time, you need to live for another fight, because you can't be sure what the courts are going to say. So symbolically, we blacked that out, and we said we would deal with de Klerk later. However, on the eve of going to hand over the report, the African National Congress took us to court, and in an urgent application. And of course, actually both applications did the Commission a favor, because I think there was so much publicity around this issue, because I remember we had met with the journalists at 5 o'clock in the morning. They were supposed to be getting copy of the report, and they were going to be sequestered until the event happened. And we made the speech, and we said, why do all these parties want to hide what is in the report? And that led to a huge conversation in South Africa around what have people got to hide. Yes, he lost the application. Of course, we handed over the report. But it certainly soured relationships for a period. And that was not so healthy. Another famous cartoon from Zafiro, which tells a story. Now, I've talked to that. This is a very interesting cartoon because there was a cut-off date for the receipt of applications for amnesty. And it took a long time to get this process working. And suddenly, when the applicants realized that they might lose the opportunity, just before Christmas, we had this rush of applications. The amnesty criteria, of course, was that you had to make a voluntary application. You had to do so and demonstrate that your act or the crime that you had committed had been done in pursuance of a political motive, either of the former state or any of its agencies, or of the liberation movements, and you had to make a full disclosure. You had to demonstrate that this was not done out of malice or greed. Professor Carl Norgaard from the European Court of Human Rights had developed some criteria for SWAPO when they returned home, and this was also used as guidelines by the Amnesty Committee. And of course, the big question of proportionality became an issue. Am I running out of time? 5 minutes, okay. Now, I think I should show you very quickly the clip that will give you some sense. But when the victims first began to speak in South Africa, most white people in our country said they're exaggerating, these things didn't happen. And of course, when the amnesty perpetrators came forward, there was this huge sense of disbelief. How could we didn't know? And I think the question is, how can you not know that these things were happening? A question around the truth, how do you get to the truth? And of course, Professor Albie Sachs, he developed these 4 different levels of truth: forensic truth, the personal or narrative truth, the question of dialogical or social truth, and of course the healing truth, which allows people to come forward and speak about what has happened. One of the things that has not stopped in South Africa is, of course, the struggle against impunity, because one of the prerequisites of the amnesty process was that if you did not apply, then of course prosecutions would follow. It is more than, was it 2005 when we handed in the final set of reports. To date, there have been 1 prosecution of a very low-level UDF person. Nobody else has been prosecuted.